We are live, Mr. Chair.
Great. Ladies and gentlemen, this is the House Judiciary Committee bill hearings on Wednesday, April 6th. Chair Clippinger is occupied at the moment. We have four Senate bills and one House bill we're taking up today, and we're going to do them in this order. Senate Bill 772, Senator Carter; Senate Bill 38, Senator Kramer; two bills from Senator Lee, Senate Bill 377 and 33. And then lastly, Delegate Motz with HB 1476. These are mostly sponsor only, but we'll start with Senator Carter, SB 772. You have 3 minutes when you're ready.
Thanks, Mr. Vice Chair, and thank you, members of the Judiciary Committee. I believe this is my last bill before you this session, and so I promise to make it as painless as possible. I believe it's sponsor only. We did have testimony in favor of this bill. I had a whole panel in the Senate, and I'm happy, if you don't already have it, to share the testimony of the stakeholders in this, because I think the expertise that lawyers that work in the realm of parental representation had to offer was important. But at any rate, Senate Bill 772 alters the definition of neglect and statutory provisions that govern child in need of assistance proceedings. The bill specifies that, except under certain circumstances, neglect does not include the use of marijuana by any parent or individual that has permanent or temporary care or custody or responsibility for supervision of a child. In 2017, 651 children nationwide were placed in foster care because of parental drug use. Among that number were children whose parents only use marijuana. While typically not the only issue when children are brought before the court in civil cases, marijuana is generally used as an additional evidence against a parent challenging their ability to care for their child. However, far too often, for many parents, marijuana can be the sole barrier to them regaining custody of their children, even for parents who have been determined by the court to have successfully addressed issues of parenting, mental health, housing, et cetera, in a positive toxicology for marijuana. Still, in some instances, is the sole basis for preventing parental unification. And so my testimony is written, it's long. The bottom line is that as we are moving toward the legalization of marijuana, it's absurd that we would continue to have parents lose their children and be prevented from having their children reunified with them because of the sole use of marijuana. The Senate bill Senate made one amendment, which I'm good with, which it clarified that we're talking about the mere use of marijuana not being a barrier to parenting. And so I'm totally happy with that. And be clear, this has nothing to do with some of the issues that were raised in our committee about using in front of a child and doing, other things. This is simply that you wouldn't be barred from having your custody of your child because of the mere use of marijuana. And with that, I'm happy to take questions.
All right. Are there any questions for the sponsor? We got one from Delegate Sham. Go ahead.
There we go. Hi. Hello, Senator Carter. Good to see you.
Hello. You too.
Thank you. Just a quick question. Thank you for joining us today. So if the mere use should not impede a parent from not having their child, help me understand this via a scenario. So I've heard marijuana use can cause, some people to be sleepy, lethargic, tired. So let's say the parent uses marijuana and falls asleep on the couch. The child sustains an injury because the parent wasn't awake. Has that now moved into another area? It surpasses the mere use. It has now impacted the parent because they fell asleep and they weren't aware to notice that the child was in harm's way. Is that covered under this potential bill that becomes law?
Thank you for the question. I think it's an important question because my answer is no. This would have nothing to do with a parent who is neglectful in the care and custody of their child. meaning if you fall asleep and a child is injured, certainly the court could look at that as they can now and make a determination as to whether or not there was neglect and or abuse. Just like a person that drinks alcohol. I mean, think about it in these terms. We don't take anyone's child away because they use alcohol, but we would consider taking a child if their use of alcohol or abuse of alcohol made them neglectful in the care or custody of their child. But because marijuana has been illegal until now, it's been a legitimate reason that courts have used to take the kid or not let the kids reunify with the parents. But now that we're moving to, if we believe that marijuana and not having marijuana prohibition, then as it would be legal, it should not be a sole reason to have someone lose their children. That's the only thing that we're saying. Certainly, if a person is neglectful or abusive, that still is reason, could be grounds to take their kids or not return their kids.
Thank you very much, Senator.
All right, are there any other questions for the senator? All right, well, that's going to conclude the hearing on Senate Bill 772. We're going to go now to Senate Bill 38. Senator Kramer, you have 3 minutes when you're ready.
And thank you for that, Mr. Chair. Good afternoon to you and the members of the Judiciary Committee. Ben Kramer introducing Senate Bill 38. Colleagues, last year, we passed legislation that would provide for the canine handlers when their canines are retired from service to receive up to, in any given year, $2,500 from the agency that benefited from the service of the canine toward veterinary care for the retired canine. These dogs are worked very hard during their careers. They often, at the end of their careers, do have greater health issues because they have been worked very hard. And of course, the women and men who work in law enforcement with these dogs do not get a great salary, but they do care about their canines. And when the dogs are retired, they almost universally will take their dog to their home, and their partner, their dog, will finish out its life with the handler. What did not come up is that, and I guess it hadn't even occurred to me, our fire and rescue services also have canines and canine handlers, and they reached out to me and said, hey, you know what? We face the exact same situation, the same circumstances. Our dogs are worked very hard in their careers. They do all the work we don't want human beings to be doing because it's risky and dangerous in many instances. And they said we would be very appreciative if we too could benefit from the legislation we passed for our law enforcement personnel. So the bill before you, colleagues, does just that. It amends the good work that this committee did last year on this issue to ensure that the hardworking women and men in our fire and rescue services that are canine handlers, when the canines are retired, that they too get this very small benefit toward veterinary costs for their dogs. So with that, Mr. Chair, I would ask for the committee's favorable report so that we bring parity to our fire and rescue services, which was unintentional with the bill that the committee passed last year. Thank you. Certainly welcome any questions.
All right, Delegate Garden.
Thank you, Mr. Chair, and thank you, Senator, for bringing the bill. And next year, if you have another one, I'd love to be your cross-filer on it. Does the money follow the dog, so that if it's not the handler but maybe somebody else in the unit, can they qualify for it, or is it only if the handler gets the dog?
No, it would follow the dog if the handler or another handler adopts the dog. Under most circumstances, these dogs, well, particularly with law enforcement, when the dog is retired, it's very rare that they are allowed to be adopted outside of a handler because the dogs are very specifically trained. Sometimes they can be, a little bit aggressive towards strangers. So they're not typically allowed to be adopted by anyone other than one of the handlers, and usually the one that has the dog. So it is specific to whomever, would get the dog within the agency.
Great, thanks.
And I would welcome your co-sponsorship moving forward, Delegate Cardin. Good to see you.
Good to see you.
All right, Delegate Martindale.
Yes, thank you for being here, Senator. And I just want to say, I have a question. When it says certain local entities, does that mean still, does this apply to everybody in the state that has fire, rescue dogs and police, police animals? Does that apply to every cert or just certain jurisdictions?
No, this would apply to all jurisdictions statewide, as did last year's law enforcement bill. So Prince George's County, Montgomery County, Anne Arundel, wherever the agency that benefits from the service of the K9, they would be the ones to provide the assistance. In the case of the Maryland State Police, it would be their offices, as well as the fire marshal's office here in the state of Maryland. It would be the same thing with the fire and rescue services. So it would be Montgomery County or Prince George's County. I also, forgive me, I believe I failed to share, and I think I'm correct on this, that there was no opposition at the hearings, and the bill passed unanimously.
Okay, then the other part to that question is, do you have any idea how many animals we're talking about?
You know what? We really do not. And it was interesting because and there's not nearly as many in fire and rescue as there are in K9. But last year's fiscal note for the law enforcement K9 indicated that at any given time, a large jurisdiction like Prince George's or Montgomery County might have somewhere between 3 to 5, I believe was the number, K9s that might be eligible for retirement. The smaller jurisdictions, it may have been 0 or 1. And the fire and rescue services have even fewer K9s than those that are utilized in our law enforcement agencies across the state.
Okay, thank you so much for your answer.
Thank you for the question.
Delegate McComas.
Thank you, Mr. Vice Chair. This is just a real quick question. Harford County has a number of volunteer fire companies. And so does the definition requires a state or local fire and rescue entity? Would that cover the volunteer systems?
Correct. And we had at the bill hearing here in the Senate testimony and support from both career and volunteer fire and rescue services.
Okay, I just wanted to make sure we were covered. Okay, thanks. Good bill.
All right, thank you, Senator Kramer. That's going to conclude the hearing on Senate Bill 38.
Mr. Chair, thank you. Committee, stay healthy.
We are now going to go to Senate Bill 377. Senator Lee, you have 3 minutes when you're ready.
Okay, thank you, Mr. Chairman. It's great to see all my colleagues on the House Judiciary Committee, which I had the honor of serving for 13 years. SB 377 is very familiar to this committee because you all passed out the cross-file HB 369, which just passed the Senate today. And the bills are almost identical with just one small differences. And as you know, this bill establishes a process and requirements for the issuance of a new marriage certificate when the name of the party to the marriage has been changed. The process can already be done, but there's a lot of confusion in the process. So this bill just creates a standard system to issue the new record of the marriage with the updated names. The Senate bills cross-file, of course, your bill, HB 369, was amended to account for the concerns raised by the clerks of the court. They wanted to change from paper to electronic records, and that is reflected in the House bill. And the Senate bill already had passed out before we got to your bill. So I would respectfully request that you conform my Senate bill, SB 377, to what passed out in the House, HB 369, with that one amendment dealing with electronic records so that the bills are identical in form. I respectfully ask the favorable with that amendment.
All right. I don't see any questions. So thank you, Senator Lee. Let's move on to.
Mr. Chair, you have those amendments, is that correct? I assume that you do. It just conforms it to the House version, that's all.
Got it. Yeah, well, I put a note here.
Okay, I just didn't want any kind of delay in any procedural matters. Okay. SB, oh, I'm sorry, Mr. Chair, do you want me
Yeah,
to?
go ahead. Senate Bill 33.
Okay, SB 33, as you recall, is a bill familiar to you too. It passed last year along with the House version. This year's House version is HB 153, which just passed with an amendment in the Senate today. My bill, as you know, repeals marriage as a defense to sex crimes. However, there was a difference. The bill was amended by my JPR committee to include language dealing with consent for people in a sexual relationship. And House Bill 153 passed the Senate with this amendment too. So the bills are identical, but however, I leave this bill, my bill, to the discretion of this esteemed committee as to what they want to do. If you want to do a conference committee, I would like to respectfully ask that you do it as soon as possible. And I thank your indulgence.
Delegate Bartlett.
Thank you, Mr. Chair. Hi, Senator. Good to see
Hi,
you.
good to see you too.
Thank
Happy
you.
anniversary.
Thank you. I'm looking at the amendment and I don't understand the physical contact commonly engaged by two individuals in a sexual relationship. That to me seems very broad. And are we using, and whose standard are we using as to what is commonly engaged? It just seems kind of weird to me. How do we measure that?
I don't know what the standard would be for this particular definition of sexual conduct between two in a sexual relationship. This amendment was put on towards the last part of the voting session. And there was not any hearing on this provision, or during the hearing that we had on this bill, we did not discuss this.
Okay. And also, I also have a problem with the word, unless one of the individuals has reasonably indicated. I have problems with that too, because that can actually be used against the victim because it's so broad. It could really be used against the victim. I think, and I'm gonna say, isn't that so? I kind of feel like, would a hearing, okay, let me ask you this way. In your opinion, does this amendment change the definition of sexual contact and has less to do with what the original purpose of the bill was?
Yes, I believe so.
Thanks. Thank you, Senator.
Delegate Shetty, then we'll Crutchfield.
Thank you so much, Mr. Vice Chair. Thank you, Senator Lee, for your tireless work on this issue, along with our wonderful committee colleague, Delegate Crutchfield. I too am a bit confused by the drafting of this amendment. And I also have concerns that this is taking the bill to a different place than was originally intended. And I love the original bill. I thought it was well thought out, well drafted, and really tries to clearly explain essentially that, regardless of your marital status, that you have not consented to rape or any other type of sexual assault. So I'm concerned about some of the language, and I know you mentioned that this was added sort of later in the voting session, and I'm just wondering if you could perhaps clarify any of the discussion that surrounded the amendment, particularly around whether the committee discussed or got input on what reasonably indicated means, that the further contact is unwanted. Thanks.
I don't recall from the hearing or the discussion we had that there was a lot of discussion about what exactly that entailed or how it would be or how it's been interpreted.
Okay, so there was,
But there was, I think the controversy was around the fourth degree sexual assault. And so that's why I believe that this solicited the amendment from one of our committee members. And the vote on this amendment was 6-5. So yes, there wasn't too much discussion, I thought, on the issue of consent.
and so then may I presume then there was no discussion also on what reasonable versus unreasonable indication could be?
I don't think there was substantive discussion on it. Correct.
Okay, all right. I am concerned that this amendment is harmful to the intent of the bill. I'm concerned that this amendment language specifically wasn't adequately discussed, and that there are some significant drafting issues with it as well that really would make it very difficult to enforce potentially, if ever under question or under scrutiny. So I am grateful again so much for your work on this bill, and I look forward to us having a greater discussion during the vote session, and if there's a conference committee for us to sort it out. Thank you.
Yes, thank you, Delegate Shetty. I will leave this up to the wise discretion of this esteemed committee to decide how to proceed on this.
Thank you, Senator.
All right, Delegate Williams.
Thank you, Vice Chair, and thank you, Senator Lee, for all of your hard work on this bill. You sort of talked about this a little bit. I know in your remarks you had mentioned that there were some modifications made to the bill as it related to consent. And I would just say, for me, I feel like consent is just like a fundamental right of the individual person. It's just kind of my personal thought on that. And so I think it sounds like there wasn't a lot of discussion about how JPR came to the definition of consent that it came to, and I guess that was one of my questions was, in terms of consent, did the committee look at definitions in any other states like Minnesota or in the District of Columbia? I know I had a bill several years ago, kind of similar, that was looking at consent. We tried to look at what other states, were doing as it related to kind of defining what consent is, because again, I feel like that's the right of the individual person. And so just wanted to get some clarification about that.
Yes, thank you, Delegate Williams, and also your work on issues dealing with domestic violence too. I do not recall that we looked at other jurisdictions like Minnesota, District of Columbia, or Washington State or Illinois, or those other jurisdictions. I do not recall that.
All right. Well, thank you. I appreciate that information. Maybe we can figure out how to best work this so it makes it very clear that consent is that individual right. So thank you.
Thank you.
Delegate Crutchfield.
Thank you very much, Mr. Chair. And thank you so much, Senator Lee, for continuing to support, encourage me in particular with the cross-file of your bill. And again, just partnering with me for these last 2 to 3 years on this very important effort. So I thank you very much for that. But I wanted to kind of ask you a question, just a really quick question, but I do understand that the changes that have been made are the result of continued, I guess, concern by some of the senators in your committee regarding fourth-degree sex offense. And that actually was something that was also presented on the floor of the House of Delegates as well. And in fact, they took it to the point of even changing the title of this particular bill to put in a reference to fourth-degree sex offense. So my question to you is just very, very simple. Do you think this amendment is necessary on this legislation?
Well, I would leave it up to the discretion of this esteemed body, the Judiciary Committee, to proceed ahead and look at those issues and of course, decide how you want to proceed.
Thank you.
All right. Are there any other questions for the senator? Seeing none, that's going to end the hearing on Senate Bill 33. Thank you, Senator Lee.
Thank you.
We are going to go now to House Bill 1476, Delegate Motz. You have 3 minutes. Is he with us? Johnny?
Can you hear me okay?
Yep. You got 3 minutes when you're ready.
I'm sorry, I'm testifying. We're voting in my committee. I apologize, colleagues. Thank you. It's an honor to be here with you today. I'm testifying on behalf of, we've got Senate Bill 997. I've got the right bill, don't I, Mr. Chairman?
Yes, and actually, can you, sorry, I apologize, Delegate. I may have skipped a witness on that last bill. Will, do we actually have someone waiting on this or no? I'm sorry. I'm sorry, Delegate. We'll come right back to you.
Thank you.
Yep. All right. Sorry. I concluded the hearing on Senate Bill 33 prematurely. We do have one witness signed up. Lisa Jordan, you have 2 minutes when you're ready.
Thank you, Mr. Vice Chair, members of the committee. I'm Lisa Jordan at the Maryland Coalition Against Sexual Assault. The Maryland Coalition Against Sexual Assault supports Senate Bill 33 only if amended, and we really thank this committee and also Senator Lee for her work on this issue, and thank this committee for reporting favorably on House Bill 153 without those amendments. The amendments that the judicial proceedings placed on this bill are really unfortunate. There are 3 reasons that you should reject them. First, it is bad policy. Second, there was not a full hearing on the issue of redefining sexual contact or consent. And finally, as you've heard, the amendment itself is very badly drafted. First and foremost, this really is bad policy. The amendment says that you have given blanket consent to certain types of sexual touching if you're in a, quote, ongoing consensual relationship. MCASA believes firmly that relationship status does not and should not substitute for consent under our laws. We're joined by this by the Attorney General's Office, by the Maryland States Attorneys Association, the Women's Law Center of Maryland, the Network Against Domestic Violence, and others who believe that each of us, like Delegate Williams said so eloquently, we should have the right to consent and refuse sexual touching as individuals. Second, there has not been a hearing on this issue. If the Maryland General Assembly wants to change the meaning of consent for couples or for anyone, you really should, we would respectfully suggest, have a hearing on that very important issue. And finally, as you've heard, the language of the amendment is seriously flawed. In particular, that idea that there would somehow be an unreasonable indication that you wanted to deny physical contact it's very perplexing. What would an unreasonable indication be for sexual contact with, just as a reminder, it's the intentional touching of the victim or actor's genital, anal, or other intimate area for sexual arousal or gratification, or for the abuse of either party. We respectfully suggest that you should have the right to consent or refuse to that as an individual without regard to your relationship. And therefore, we urge the Judiciary Committee to reject these amendments and conform Senate Bill 33 to House Bill 153 as it passed the House of Delegates. Thank you, Mr. Vice Chair.
All right, thank you very much. Any questions for this witness? All right, we got one. Delegate Grammer.
Thank you, Mr. Chair. Ms. Jordan, can you please run through the, this amendment that came over seems to be a bit wonky. Can you please just walk me through that one more time?
Yes, thank you for that question, Delegate. It says that for the purposes of the 4th degree sex offense, in the case of 2 individuals who are engaged in an ongoing consensual sexual relationship. So first question, what does that mean, ongoing consensual relationship? Is that what happens when you're in the middle of a breakup? What happens if you have a couple of teenagers? What does that mean? Then it says physical contact commonly engaged in by those 2 individuals in a sexual relationship, or actually it says by 2 individuals in a sexual relationship. Again, what does this mean? Is that commonly engaged in your community, in Maryland, in between the 2 couples? What if one person has a different idea about what's commonly engaged in than the other? And unless one of those individuals has, quote, reasonably indicated to the other that further contact is unwanted, which I appreciate the desire to say, oh, you could say no, but I'm very concerned that you can only say no in a reasonable way. What does that mean? What would an unreasonable indication be? And so what the amendment does is it places all of that language into the definition of 4th degree sexual offenses, the definition of sexual contact. So it's really kind of an end run around consent. And it may be a policy issue that the General Assembly wishes to address, but I would respectfully suggest that this is really a very, very sensitive issue. It raises a lot of concerns about our individual rights, our individual autonomy, our control of our bodies. And so if the General Assembly is going to go in this direction, would respectfully suggest that someone introduce a bill and have a full hearing on it. So appreciate your question very much.
So, and also the amendment that has been sent over also goes a little bit outside the scope of the bill in changing the definition of 4th degree. Is that correct?
That's totally correct. The bill was introduced simply to repeal spousal defense. So repeal the idea that marriage could be a defense to sex crime. 4th degree is a separate issue.
Okay. All right. Thank you so much.
All right, Delegate Bartlett.
So this is scary because if the person is asleep or otherwise like intoxicated or something, and they cannot indicate that the physical contact is unwanted, does this amendment say that if they can't do that, then it's not 4th degree sexual assault?
Well, it seems to fundamentally change the way we look at consent and say that there's an assumption that you have given kind of blanket consent to sexual touching if you're in this type of relationship. So in any of those circumstances, I think the analysis would be, you start out with, you've given blanket consent, and have you given any reasonable indication that you don't want that sort of touching? And is the touching that occurred something that's commonly engaged in by 2 individuals in that relationship, which again raises the specter of a trial where you would be asking the complaining witness, what they did sexually, was that commonly engaged in? If it's an individual standard, perhaps it's a community standard, and then we would have to go for community experts in, what sorts of touching are commonly engaged in. It's really very, very flawed language in addition to the overall policy concern.
This is very unfortunate. Thank you. Thank you.
All right, thank you very much. Now, apologies, colleagues, that will conclude the hearing on Senate Bill 33. And apologies to Delegate Mouts. We can now return to House Bill 1476. And again, if you are still with us, you have 3 minutes when you are ready.
Thank you, Vice Chair and colleagues, and I appreciate your patience. I got caught off guard there a little bit. We're doing a big voting session in ECM right now, and I have both computers on. I thought I heard my name, but I didn't really realize it, and I looked over and thought, oh no. So I grabbed my papers. The bill I'm presenting today, Johnny Mounts for the record, Talbot, Caroline, Dorchester, and Wacomico counties. The bill before you today is HB 1476. It's a delegation bill out of Talbot County. HB 1476 would authorize Talbot County local detention center officers to participate in the correctional officers retirement system in the event that Talbot County becomes a participating government in this system. Right now, the Talbot County is not, and this simply would authorize Talbot County to take the steps to consider whether or not that's something they would like to do. This legislation was requested originally by Mr. Terry Kokolas on behalf of the correctional officers in Talbot County. It passed. There's a Senate bill currently in the House that passed unanimously. This is something that's been endorsed locally, and I'd appreciate your favorable consideration and urge a favorable report for HB 1476. Also in the Senate, Laura Price, who represented Talbot County and is with MACO, testified on behalf of the bill there. She was not able to testify today. We had a short notice, but she's also willing to offer her support for this legislation. Thank you, Mr. Vice Chairman and colleagues. It's great to be with you.
All right, Delegate Garden.
Yeah, thank you, Mr. Chair, Mr. Vice Chair. Delegate Motz, does the immense, huge Talbot County delegation have a letter of support?
Yeah, we organized one. Is there not one in the file?
No, I think there is. I just want to make sure because all of what, two of you?
Well, yeah, for the House, we've got two, but we're known for filling a room.
Thanks.
Yeah, we do the best we can, and I appreciate it. So thank you for that. And yeah, the delegation is on board.
All right, thank you, Delegate Motz. That's going to conclude the hearing on House Bill 1476. It's going to conclude the hearings for the Judiciary Committee today. We do have subcommittee chairs meeting later this afternoon. Stay tuned for that time. And a voting session is happening later this afternoon, likely around 5 p.m. But again, stay tuned for those times. Delegate McComas.
Thank you, Mr. Chair. I just wondered which subcommittees are meeting.
No. The subcommittee chairs.
Oh, the chairs. Okay.
Yeah. Subcommittee chairs will meet later this afternoon.
Okay, gotcha.
Excuse me. Let me clarify. And the full committee will meet for a voting session on the tail end of the afternoon. Again, stay tuned for the time, but it's probably around the 5 o'clock hour. All right. See y'all.